Okay, good afternoon, everyone. I hope you can hear me. May, can you hear me?
I can, Gareth.
Good. We've got people starting to join, so we're going to get going. It's 12:30. I suspect people might start to filter through as well. But the purpose of this talk is that it's supposed to be a law with lunch. So you've either all eaten your lunch and you're now going to agree to spend half an hour listening to me and I talk to you about practical tips in the employment tribunal, or you might be sat at your desk with a sandwich or a salad. So we don't want to take up your time unnecessarily. I'm a barrister at Partly Employed and Chambers, so is May, and we're both employment law specialists. We're going to talk to you today about practical tips in the employment tribunal. And the idea behind this talk is that it's not a how-to guide in terms of running litigation in the employment tribunal. We assume a fair bit of knowledge of everybody that's joined in. It's also not really for seasoned litigators. We're probably not going to be telling you anything unusually new or surprising if you've spent a fair bit of time in your practice litigating in the employment tribunal. But we think it's probably going to be helpful to perhaps give those who have some experience but are not seasoned litigators some tips and hints on where they might gain an advantage over their opponents as they go through the course of litigation. We're going to try and keep it short. The aim is to do it within 40 minutes, certainly, maybe half an hour. The talk is split into two parts. May's going to go first. She's going to talk to you about, I think, 8 or 9 slides up to around about the stage of dealing with preliminary hearings, and thereafter I'm going to talk to you and deal with points to be taken as you go through the hearing stages. There are slides, of course. We're talking to you with the slides, but if you want the slides being emailed to you afterwards, please just email us and we'll get those to you. There's a chat box as ever. Please put questions in there. We'll try and monitor it and we'll try and deal with any questions that you have that way. I'm told to tell you that we are recording this. I think you might have got an alert when you joined in. That's just because we record all of these law with lunches so they can be utilised after. But if there's any case-sensitive questions or Q&A session at the end of any note, that bit won't be recorded to try and maintain some degree of confidentiality. But of course, as ever, if you've got a particular question about a particular case that you're working on that you'd like our help with or just want to have our thoughts on, then it's probably better just to pick up the phone. All right, we'll get going. Over to you, May.
Thanks, Gareth. The first thing we're going to touch on is probably slightly predictably about the rules of the employment tribunal. There's sometimes a tendency for the employment tribunal to feel a little bit like the Wild West, and you get the employment judge riding in on his horse and being some sort of sheriff who essentially does whatever he wants to. That's not how it should be. There are rules with which the employment tribunal has to work within, and as well as the rules, there's particularly important guidance on case management, which is a presidential guidance. So everything you're doing in the employment tribunal, make sure that you are familiar with the employment tribunal rules, the presidential guidance, and that you're really using those to your advantage. The guidance in particular, it's particularly helpful on things like amendments to claims, disability, remedy. It's the sort of thing that the rules touch on but don't really go into detail about. The guidance is much more helpful on those. So make sure, in effect, you're friends with both the rules and the guidance. Within that, the overriding objective is possibly your most powerful tool. Make sure that you're using its language when you're making applications or writing correspondence, and throw in references to the principles of fairness, of proportionality, of flexibility, because when the tribunal is making any case management decision, that's what they have to have regard to. So if you've already shown them how what you're asking for satisfies those requirements and fulfills the overriding objective, it's so much easier for a tribunal to grant you whatever it is that you're asking for. The next slide is about brevity, so I'm going to deal with it quickly, I hope. There was a study done by Microsoft not so long ago which showed that the average attention span of a human is 8 seconds. So what that means is it means most of you have already switched off. It also means that Gareth is probably not going to have many people to talk to by the time we get to his section. But in terms of the employment tribunal, it means that if the pleadings are 30 pages long, whoever is reading it is not going to be engaged by the time they get to page 30. In all probability, they'll have switched off at about page 5 or page 6. So you have to keep pleadings short. All they need to be, you can see there the guiding principles, the key facts that form the basis of the complaint, and the legal position based on those facts. That's it. That's all it needs to be. You can save everything else, the detail and the background, for the witness statements. The other thing to touch on here is that more claims do not equal a better chance of success. It's the opposite. If you've got 2 strong claims, just bring 2 strong claims. If you bury them amongst 8 others, all that does is it, when the tribunal looks at it, they'll see 10. They won't know which 2 are your best 2. And you risk the tribunal missing your best points because you've hidden them amongst a sea of others in an attempt to flesh out the claim. Further and better particulars are tempting. We've all done it. You get a claim in, it's quite vague, it's a bit confusing. It doesn't really give you a picture of what the complaint is. And the instinct is to write back straight away and say, I can't deal with this. I need further and better particulars, please. And what inevitably happens is you get back a very, very lengthy document. It's full of things that weren't in the original claim. And it's probably not actually any clearer than the original claim was to start with. So all we've achieved is increased the volume of material that we've got to work with. It's all still confusing. There will need to be a preliminary hearing to sort it out. So if you can, if there is enough from the original claim that you can take instructions on it and you can respond to it, just leave it well alone. Don't ask for further and betters, because it gives your opponent a second bite, a second opportunity to complain or to respond about something. If you feel that you do need to ask for further and betters, there are 2 ways really that are helpful in making sure that you don't end up with reams of further information. The first way is to write your request for further and betters, identify what it is that you need to know, send it to the claimant, but in advance of a preliminary hearing, and say to them, please do not attempt to fill this in or to respond to this before the preliminary hearing, when the judge can help you. If you then have a case management PH and a judge is minded to deal with it, you get the extra information that you need, but you have a judge who's immediately on notice that they are further and betters and they're not an opportunity to expand the scope of the claim. The other option you've got is consider asking for a Scott schedule, which in effect is a table with columns breaking down the claims into the key facts and the key legal elements. So there'll be a column for when did the alleged act occur, and who was the alleged perpetrator, where did it happen, what words were said, and then columns with the legal information in. So what's the PCP that you're relying upon? What's your disability that you rely upon for this particular allegation? Who's your comparator? And what that does, the real benefit of a Scott schedule, is it very much highlights when there's a claim with gaps in it. And that can help you if you want to go on to make a strikeout application, because you can see where the weaknesses are, and so can any judge who looks at the Scott schedule. The list of issues, in my view, it is the most important document by the time you get to a final hearing. If it's done well, you can in effect put the pleadings to one side. You don't really need to look at those anymore, because everything that's in dispute and needs to be decided upon is in your list of issues. It's a roadmap or a flow chart, I suppose, for VET to determine the claim. It poses the questions they need to ask, and you can see exactly what answers will lead to a successful claim or to a successful defence. If you do a proper detailed list of issues, it takes time. There's no shortcuts to it, because you need to understand the claim before you can draft a good list of issues. But I'd always say that it is worth that time investment because of the time that it will save you and everybody after you when they come to look at the case. This slide is on deposit orders. These are often applied for as an alternative to a strikeout, but I've found that especially in discrimination cases, they are much, much more useful than a strikeout application, because in effect, there is so much case law which says to judges in big red letters, do not strike out a discrimination claim. But if you look at the case law on making deposit orders in relation to discrimination claims, there's just not the same caution that has to be applied. In reality, the two can have the same consequence, and in that if you get it struck out, your claim is gone. That's the end of it. But with a deposit order, it takes a very bold claimant to go to a preliminary hearing, to hear a judge tell them that their claim is weak and to set out the reasons why, and then to tell the claimant that if they pursue it and if they lose, they're at risk of costs. I certainly haven't found that there are many claimants who, faced with that, go on to pursue it at trial. There's a case on the slide at the bottom there, Hemden. That was a case about the amount of the deposit order. And what was essentially said is that the tribunal shouldn't set the amount so high that a claimant can't pay it, because what you're effectively doing there is a strikeout through the back door. The initial amount there was £75 per allegation, and the EAT changed that and said, no, it should have been nominal, £1 per allegation will do. From the respondent's point of view, the amount of the deposit order doesn't really matter. The real thing of value for a respondent in the deposit order, it is the fact that it puts the claimant at risk of costs, and it's a real deterrent to actually running things on to trial. This one is short, and it's a plea, I suppose, on behalf of tribunals everywhere. They're busy. They haven't got enough staff to do everything that they need to do. Everybody there is overworked, tired, and under a lot of pressure. And so if you email the tribunal or if you write to them, chances are there's going to be a pretty long delay in them responding to you. The consequence of that, if you can sort an issue out yourself between the parties by both of you essentially agreeing to be eminently reasonable, and you can sort that without needing the tribunal to deal with it at all, then do so. The slide's entitled Dark Arts, and I think that's probably quite fitting in that I think the tendency when you think about directions in case management orders is just to think, oh, well, they're standard. The judge will order them by reference to the standard time frame. Nobody's really going to have a dispute about when the orders are for. And so let's just leave it. That's something we don't need to worry about. But actually, there's something that you can use quite helpfully to your advantage, in that all of the orders made will have a consequence in terms of costs, because disclosure costs money, and it costs the respondent usually a lot more than it does the claimant. Witness statements cost money. Preparing a bundle costs money. And I don't think it's a generalization to say that respondents hate costs. And if you're acting for a respondent, there's a possibility that it's a case that will settle. You don't want the directions to be so front loaded that all of the work is done and all of the cost is incurred and the case is completely ready for the trial a year before the trial is even listed. In those sorts of situations, you want the directions as far back as possible. And something that I've found is that the tribunals are alive to that. If you're at a case management preliminary hearing and you're thinking about settling, judges do sometimes give you leeway and will agree to push the directions back if that's going to have a chance of increasing settlement. Judges are sometimes receptive to it. In terms of the length of a final hearing, at the minute, given the backlog of cases, it seems that any length of hearing is taking a year, 18 months to get to trial. The consequence of that, it encourages claimants to settle usually, because it's so far away. The prospect of litigation hanging over them for 18 months is unattractive to a claimant, but also to a respondent, because they want the matter dealt with and they want the certainty. So given that the hearings tend to be listed so far away, I think settlement comes to the fore and really becomes a much more important consideration that needs to be taken into account at an early stage. My last slide is all about what a tribunal will read when they read a bundle in preparation for a case. What they definitely don't do is get the file, open it, start at the beginning and read it cover to cover. There just isn't the time for that. What they'll do usually is they'll take the pleadings, they'll look at those, they'll look at the list of issues, and then they'll look at the lead witness statement from each side. In terms of the documents in the bundle, the only ones that they'll tend to look at are the ones that are referred to in the witness statements. So what that means is that it's crucial in your lead witness statement that the narrative that you want to put forward really flows through, because that's going to be the tribunal's first impression before any evidence is heard of what your case is. And if you're going to back that up by documents, and there are really key, crucial documents you need the tribunal to see in advance, make sure they're referred to in that lead witness statement and make sure that it's compelling. That's your chance to win over the tribunal right from the start. That one is my last slide. So I'll now pass you over to Gareth, who will take you through the second half and give you some more tips.
Right. Just on May's last slide, there is in fact on YouTube it's quite a, I think been up for a long time now. There's a little 25-minute talk from Sean Jones, QC11 KBW, about witness statements, about, I forget what it's called, something like the deadly sins of statements or witness statements. I wholeheartedly recommend anybody who is struggling with drafting witness statements or wants some tips on particularly how to draft witness statements to look at that. Lived experience. And what we mean by this slide is it's a sort of an adjunct to what May's just spoke about in terms of the witness statements, which is you are, whether for claimants or respondents, dealing with facts that occurred some time ago. Claimants are likely to have a very strong recollection of those facts because they lived them. It's their claim, it's prompted them to seek out legal advice, it's prompted them to get to the stage of actually pursuing litigation in the employment tribunal. And it is a course of events or a series of events that are etched into their mind. The downside to that is claimants will inevitably attach significance to things which objectively people might think ought not to have had any significance attached to them, but claimants become focused on all of the details and consider everything in later hindsight to be in some way part of the relevant context and background. The reverse is usually true for witnesses for the respondent, which is that they rarely have such good recollection. They didn't live these events on a day-to-day basis. They probably at some point touched upon aspects of the claimant's work life, whether as a colleague or as a manager or in some way involved in the issue that is then coming before the tribunal. But it wasn't part of their day-to-day life, and they were just brought into that part of the narrative for a short period of time sometimes. Trying to deal with that is difficult. And for claimants, it gives an advantage. It gives an advantage in the sense that documents in the bundle that the tribunal will review can be genuinely and with the ring of truth about it added to by claimants. They're going to be able to expand upon those documents with more genuine reflection than a respondent might. That should be used to the claimant's advantage where possible. For respondents, but for the claimants, however, of course, it's then the responsibility of us who act for claimants that we should then know what's the good point about that document and what's the detail that we don't want to unnecessarily bog down that document for the tribunal's attention. We want to focus on the particular aspect that the claimant recalls and why they recall it. For respondents, that can be more difficult, but where there is something that a respondent's witness recalls, something stands out, there's a particular phrase or there's a recollection they have about an exchange that was had at work in some way. That will stand out to tribunals by the fact that respondents' witnesses will typically have to give evidence on lines of, well, the document says this, and whilst I don't personally recall, it would have been my practice that X, Y, Z. But if there's the ability, therefore, for that witness, the respondent's witness, to say, well, actually, I do remember that meeting because something unusual happened, or there was an issue arose that wouldn't typically be dealt with at that meeting, let's say, that needs including in the statements, and that needs including in the witness's account, because that will stand out to a tribunal. In this series of sort of discussions about witness statements and then the lived experience of each witness is perhaps this final point, which is, well, what is ultimately going to be happening at a final hearing, and that is the tribunal is going to be hearing from the witnesses of fact. Tribunal judges and lay members get very good at knowing who is a reliable and a credible witness, because that's their daily diet, that's what they do. And of real difficulty, and this can be an advantage to claimants in preparing, but therefore has to be recognised by those who act for respondents too, is to be cautious about witnesses who give answers confidently, but often discursively, and they don't really answer the question. We've probably all had witnesses or clients even who fall into this category. And they will often give evidence along the lines of, well, what would have happened would be this. And that should be a red flag at the start of any answer or any explanation given by a witness. Because what's actually being said is, I don't really remember what happened. The normal course of events would have been this. That might be the extent of which their evidence can, as far as their evidence can go, and that might be all that you have. And it's not always wrong, particularly, for instance, you're talking about policy issues and how policies might be applied. But that has to be borne in mind that that's going to be placed up against the claimant's evidence usually, or claimant's witness evidence, which is, I remember that this happened. And so whilst it might be a confident answer and an answer which a respondent's witness might say boldly and confidently, what the tribunal in fact is going to hear is something did not happen versus we would normally not do this. And it's the recollection of fact, provided it's supported by contemporaneous evidence, let's say, and it has the ring of truth about it, it's the recollection of fact the tribunal is probably going to prefer. So if acting for either party really, where you have a witness that falls into this category, think about how you might be able to control the evidence that they're likely to have to give. Can somebody else give more factually accurate evidence about the issue they would otherwise give? Is it really critical? Can it be pared down in some way so you're not over-reliant upon a witness who's going to go into a witness box or sit behind a witness table and effectively say along the lines of, I don't remember, but we would normally. And the extent you can limit that, the better. This slide is about those scenarios where you are all prepared for a final hearing. There is a large bundle of documents which you've spent many hours preparing, and you turn up on the first day, and your representative or your counsel or even the representative from the firm says, well, actually, I haven't got this document and I need it. Where is it? That needs to be prepared for. So there needs to be anticipation of the fact that on the first day, there may be some document that for some reason is not with the person who is going to be presenting the case. That just means that you need to be prepared for that. And if either you're at your desk at 9 a.m. or somebody who knows the file is at the desk at 9 a.m. and can provide to counsel or to the representative something that's missing. And the reverse is also true, which is, well, it's not missing for your representative, but that the other side turns up with a new document you've never seen, and sometimes more than one document. That commonly is the case with litigants in person who don't appreciate the importance of preparing bundles and the importance of prior disclosure. A good tip, I think, is prior to the final hearing, not less than 24 hours before the final hearing, you get confirmation, or at the very least flag up with the litigant person on the other side, that the bundle has all of the documents that are going to be referred to at the hearing. You may have already dealt with this prior in disclosure, you may have dealt with this when you were exchanging emails to this effect, but it's always good as a last minute thing to say, not necessarily because it will actually get the litigant in person to produce the document, it may not, but it's actually there for the fact that when the litigant person does produce a document that's never been seen before, or says, I now want to rely upon this, which I haven't previously disclosed, you're in a lot stronger position to say to the tribunal, we alerted the litigant person to this, we've expressly asked them for it, and they didn't tell us about it. And it puts you in a stronger position to oppose any application to rely upon additional evidence. It's not the Old Bailey, but your client witnesses won't know that. And what we mean by this is, whilst we may all be reasonably familiar with employment tribunal processes and employment tribunal hearings, it's rare that your witnesses will. There's a few tips on the slide. I'm not going to go through them all, but we think these are probably quite helpful to in some way reduce the nerves that your witnesses or clients might have about having a final hearing. Most of them are trite and obvious. The couple I'll point out that I think are particularly useful and usually quite effective is the first one, which is a conference. It need not be in person, but a conference that does not discuss the issues or the merits of the case. And the reason for that is, by discussing the issues and the merits of the case, you inevitably end up discussing that particular witness's evidence, and the inevitable question comes, which is, well, what am I going to be asked, and what do I say if they ask me this or that? And that's where the nerves are. Now, you may have to deal with that, and it might well be proper to have a conference to deal with that. But a conference which just calms the nerves and allows the witness to understand the process and what's going to happen, and there isn't a discussion of the merits, is, I think, quite helpful. The other one is about the composition of the tribunal. It's something that is rarely thought about by employment lawyers because we're used to it, but the fact there's going to be 3 people, and if it's an in-person hearing, physically sat behind a desk can be quite imposing. Knowing that that's going to happen, and they're often now tribunals, they are sat in the room when you walk in. You want your witnesses and client to be prepared for that. Again, it can be explained to them who those people are going to be, what's their background, what are they going to be deciding, how does the interaction between them work, the fact that they will ask questions, and that's not unusual, and the witness is not doing anything right or wrong when they are giving evidence and the tribunal starts to ask questions. Just the more information that they can have so that they're not caught off guard by what's going to happen, as well as the fact, of course, that you're going to be in a tribunal hearing room and not the Old Bailey. The claimant won't know that. This is perhaps a tip for respondent lawyers. It might well be the case you've got to a final hearing, but it's been a case you've been trying to settle, and you'd rather not have a final hearing. And it might be the case the reason that you've not managed to settle is that you've not managed to reach a level of compensation the claimant's been willing to accept prior to the start of the hearing. I would strongly advise that there is consideration given to whether or not what you thought was your top offer might be increased on the morning of the first day, perhaps during the period of time when the tribunal are doing some reading, because that's the period of time in which the claimants are probably at that point going to be most concerned and most sort of on edge about what's going to happen. It's a dark art. It's the kind of thing that as employment lawyers might sit uneasily. But if for a client you're trying to dispose of a case and not have it heard and not have a written reasons come out that then is included in the in the EET's register, then think about whether or not you can sweeten an offer slightly so that the claimant might be more willing to accept it. It's not as effective to try and do that a couple of days or a few days into the course of the hearing, because at that point, parties are well invested, have seen how things happen, they're a lot more comfortable. So think about whether or not you get instructions to improve on your offer on the first day. Well, we all know CVP is here to stay, and there is recent guidance. I think I'm going to talk about that in a moment. In fact, recent guidance about what the roadmap, as I think it's being called, is for hearings and how they're going to be heard. But for the purposes of CVP, the one underlined, unfortunately, in May of 2022 is still not being observed, despite the earlier guidance, I think in 2020, September of 2020, which is about pagination of e-bundles and bookmarking of e-bundles. Now, it's probably the case everybody on this call is now more than familiar than they would like to be with pagination and bookmarking of PDFs. But I'll say it because it is still happening. Please make page 1 of the PDF and the actual physical bundle page 1, even if that's including the index. Tribunal judges still are getting upset, and therefore they're not starting off on a good foot with usually whoever's prepared the bundle, if that's not the case, if it requires jumping around compared to what's the page number of the actual bundle versus the page number on the PDF reader. The WhatsApp groups remain really useful. Most of us probably have all utilized them to some extent in the course of a CVP hearing. Again, I would highlight that that probably remains the most useful way of maintaining communication. So if before now or you have not, as part of your practice, you set up WhatsApp groups for witnesses and clients to stay in contact with either counsel or the representative at the hearing, it is probably the best way of doing it. It's instantaneous, it's confidential, and it's easily managed by whoever's the administrator to remove the person or the witness from the group if they're in the middle of the course of giving their evidence, and then they can be added in after their off oath. So this is the slide I was mentioning about the roadmap. We are still in the case where a number of hearings are going to be heard on a sometimes in-person basis, sometimes remote, sometimes hybrid. It's probably not possible to say as a general rule or give us a general tip whether or not it's a good idea to have a CVP hearing or ask for a hybrid hearing or an in-person hearing. There's just too many variables. Probably the only guidance we could give you, but it is probably quite a good bit of guidance, we think, is, well, what will best allow your client or witnesses to give their evidence? There are other factors, of course, and cost is always one. But really, what is it about your witnesses that might allow them to best give their evidence? I've had a hearing very recently where a very tech-savvy, presumably a director of a company, struggled immeasurably doing the hearing via CVP. And it would have been much better had he been in person. And I think he would have done much better in giving his evidence than he did by giving it via CVP. So it's not always the case that just because your client says, well, I'm very used to Zoom meetings now and Teams meetings, it's what we do at work, so I'm comfortable with it. That's a very different ballgame to being sat in front of a screen, perhaps with a physical bundle in front of you too, whilst trying to answer questions or trying to find pages in a PDF and give evidence to a tribunal. It's just a different, it's a different game entirely. And so it might well be the case that you want to just ask your witnesses, well, how confident are you going to be? And you can even test it out. You can even have a dry run with your witnesses and your clients to say, well, look, this is how it'll work in practice. You know, I'm going to ask you now to look at page 28. Tell me when you're there. Once they get there, then you practice a question and you say, well, that's going to happen for an hour and then you'll get a 5-minute break. What do you think? Or do you think you would rather be in person? And I think testing it that way may well be the best way of working out how are my witnesses best going to be able to give their evidence. Just a short slide. If you ever instruct May Martin, you'll never need to know this this tip, because you'll never lose. But if you do lose a case, then you may want to consider appealing. And if you have to appeal, you've got 42 days from when the written reasons in general are sent to you, not from when they're received. The Rana case is about a scenario where there was an error by the tribunal in sending out judgments. Eventually, once I think by the Court of Appeal, it had been found, the decision at the Court of Appeal was that they were going to exercise the discretion in allowing what would have otherwise been late notifications of appeal to be run on the basis that it was not fair or proper to lay the error of the tribunal at the door of the parties. But it may not be an excuse on the facts of your case as to whether or not you're going to be allowed to extend time. So have that time frame in mind the moment that written reasons are requested. Have it in mind in terms of not I've got 42 days, but have a much shorter period in mind in terms of I'm going to be chasing it up after 7 days. At 14 days, we're going to have decided whether or not we're appealing. And by day 16, we are going to have instructed counsel to draft, or we are going to be drafting, because you're going to have a lot of things happen in the interim, and you don't want to be leaving it so late that then you are running up against a time problem. You can ward off any issues of, well, I didn't know about the fact that the written reason has been sent out, or the reason my appeal is late is X, Y, Z. By checking with your opponent that they've received it. You can simply just send them a copy of the written reasons if the decision comes out in your favor. That way, you've got that in your back pocket for when the argument comes, well, we didn't know about it, because you could say you did know about it, we provided you with a copy. That is a similar set of facts to what in fact happened in Rana in terms of how the parties came to know about it versus when in fact they should have known about it. And that period of time can be material. Last slide. It's not really a tip on how to win the case that you might have worked on, but it's what if you lose and how might you win the next case? We're all on the call today. Most of us not sole practitioners. Most of us work with colleagues in some way. And we all will lose cases. So when that happens, what can you learn for next time? And I just think one of the things that generally is still true across the board for most firms and chambers is that knowledge transfer and knowledge of employment law in particular is underutilized. What can be learned from the case? You needn't have a sit-down meeting that goes on for hours and tries to undermine and overturn precisely quite how every finding of fact that went against you. But is there one or two at most themes that cropped up in the case that you think you could learn from? Not necessarily you, but your colleagues can learn from. And if there is, it needn't be more than a short couple of points on a SharePoint file to say, on this case, this is what happened. This is why we think it went wrong. Heads up for next time. That way you just forewarn yourself and forearm yourself for the next time that issue might arise. And you're not having to relearn or reinvent the wheel every time, or a colleague every time that they have that issue come up in the case before them. That's it. I can see there's a question. Let me have a look.